Discrimination based on appearance in job applications, specifically concerning hair and beards, is a complex issue with legal implications that vary depending on jurisdiction and specific circumstances. Generally, it is not inherently illegal to discriminate against someone based solely on their appearance. However, the key lies in whether such discrimination is related to a bona fide occupational qualification, or BFOQ. A bona fide occupational qualification is a job requirement that is reasonably necessary for the normal operation of that particular business or enterprise. It essentially means that the specific appearance is an actual qualification for performing the job. For example, consider a situation where a job requires the consistent use of respirators or tight-fitting masks. Long hair or a beard could potentially interfere with the seal of the mask, thus compromising safety. In this instance, requiring employees to have short hair or be clean-shaven might be justifiable as a BFOQ. However, it is crucial to understand that BFOQs are narrowly construed. This means that courts and regulatory agencies scrutinize them carefully. The employer must demonstrate that the specific appearance requirement is directly related to the job duties and is essential for safety, efficiency, or some other legitimate business purpose. The requirement cannot be based on stereotypes, personal preferences, or general assumptions. It must be a genuine occupational need. Furthermore, employers have a responsibility to explore reasonable accommodations. For instance, instead of an outright ban on long hair, an employer might require employees to keep their hair tied back or wear a hairnet to prevent it from interfering with equipment or posing a safety hazard. The concept of reasonable accommodation is central to anti-discrimination laws, and employers are expected to make adjustments to their policies and practices to accommodate individuals' needs, as long as doing so does not create an undue hardship for the business. In the context of an apprenticeship position, it is generally less likely that a specific hairline or beard would be considered a BFOQ. Apprenticeships typically involve a learning phase, where individuals acquire skills and knowledge. Unless there is a very specific and demonstrable safety or operational requirement directly related to the apprenticeship duties, it would be difficult to justify a blanket ban on long hair or beards. For example, if an apprentice electrician will be working around exposed electrical components, long hair could pose a safety risk if it were to come into contact with live wires. In such a case, requiring the apprentice to keep their hair tied back or wear a cap might be a reasonable safety precaution. However, simply assuming that long hair is inherently unsafe without any specific evidence or job-related justification would likely be considered discriminatory. Employers must be able to articulate a clear and defensible reason for any appearance-based requirements, and that reason must be directly tied to the job duties and the safety or efficiency of the workplace. It is important to emphasize that anti-discrimination laws are designed to protect individuals from unfair treatment based on protected characteristics. While appearance is not always a protected characteristic in itself, discrimination based on appearance can sometimes be a proxy for discrimination based on other protected characteristics such as race, religion, or national origin. For example, if an employer has a policy that prohibits certain hairstyles that are commonly associated with a particular racial or ethnic group, that policy could be considered discriminatory, even if it is not explicitly based on race or ethnicity. Similarly, religious beliefs may dictate certain grooming practices, such as wearing a beard or a turban. Employers must be careful not to implement appearance-based policies that inadvertently discriminate against individuals based on their religious beliefs. The key takeaway is that employers should carefully consider any appearance-based requirements and ensure that they are based on legitimate business needs and are not discriminatory in effect. Employers should also be prepared to justify their requirements and to provide reasonable accommodations whenever possible. Apprenticeship programs have guidelines that must be followed. It is also important for job applicants to be aware of their rights and to speak up if they believe they have been subjected to unfair discrimination. If a job applicant feels that they have been discriminated against based on their appearance, they may have legal recourse. They can file a complaint with the appropriate government agency, such as the Equal Employment Opportunity Commission, or EOC, or they can consult with an attorney to discuss their legal options. It is also worth noting that some states and localities have laws that specifically prohibit discrimination based on appearance. These laws may provide broader protections than federal law and may apply to a wider range of situations. Therefore, it is important to consult with an attorney or employment law expert to determine the specific laws that apply in a particular jurisdiction. In conclusion, while appearance-based discrimination is not always illegal, employers must be careful to ensure that any appearance-based requirements are job-related, non-discriminatory, and based on legitimate business needs. Apprenticeship positions are subject to the same anti-discrimination laws as other types of employment, and employers should be particularly cautious when implementing appearance-based requirements for apprentices. Job applicants should be aware of their rights and should speak up if they believe they have been subjected to unfair discrimination. If you are an employer, it would be best to discuss with your legal counsel. Always research on the government website for the